So, hello everyone. Obviously we can't see each other, so that's not really convenient, but the idea was basically to try to perhaps think about some more fundamental issues together that unite whatever I have heard this afternoon. I wasn't with you this morning, but I suspect that the content was along the same lines. I hope you can see my presentation. Do I assume that people can see the presentation? Yes. Okay, very good. So the idea is to try to connect to what has happened in the past few months, and that has kept us all in our respective countries at the moment. And the idea is to try to see what lessons we can learn from COVID-19 and what it has meant for access to justice and all the principles that fall under access to justice. First of all, I would like to introduce you to a very, very interesting global project, which is led by some colleagues of ours, based all over the world, including in Europe. The main people are in Brazil and Australia. And the project is a truly global project. I have given you the link, Global Access to Justice Project. It's a project that has been going on for a few years, and they very early on reacted to the impact of COVID-19 on access to justice across the world. And as you will see, with our help, so with the help of all the researchers throughout the world working on the project, and the methodology was questionnaires, they came up with preliminary data on, well, impacting access to justice in 51 different countries. So what did we look at, and what were we asked to look at? Well, to give an overview of measures at national, EU and international level, to pay particular attention to vulnerable groups in our jurisdictions, and to give an account of any change in the judicial and legal aid systems in the country where we're located. I gave you also the link to the booklet. The booklet contains very interesting graphs, and I'm sure you will find your country as well mentioned in the study. So it's something really to have a look at. So with their permission, I'm reproducing here some of the findings, the initial findings of the study, because they are truly interesting. You can see here the type of special measures that were imposed to curtail the spread of the disease. And of course, there is 100% special care recommendations. You can see the amount of countries imposing travel restrictions from outside the country, entry restrictions, but also restrictions on foreigners. You can also see the impact on the education sector. We are all, of course, very concerned with this, and we have all been affected. And you can see that this is a worldwide trend. And also closures of non-essential businesses. You can see that this was also widely followed worldwide. Again, social isolation measures, which for the first time were taken on such a wide scale and became mandatory in many, many countries, which of course has an impact on many aspects of the judicial system and the justice system, because penalties were imposed in specific countries. You can see the amount of penalties for breach. You can even see that some countries have imposed imprisonment as a penalty. It's 41%. So that's a big amount. Human rights violations at the beginning of the crisis appeared to be under control, largely with a 61% perception that there were no COVID-19 related human rights violations. I suspect that if we do that questionnaire again the picture will change. So it was rather a not yet rather than a no, I think. Another very interesting aspect, of course, is the concentration of power under the pretext of emergency measures. And here you have an interesting 71% that said that there was no concentration of power. Well, if you look at the main jurisdictions that we hear in the news or we see in the news, we mainly see the executive dealing with them, with those measures rather than the legislative. So maybe this has changed as well. Special measures taken by the judicial systems to mitigate the negative impacts of COVID. So, of course, there have been various responses. Specific countries were probably more prepared digitally to cope with the crisis. Countries such as Cyprus or Greece or countries in Latin America in particular were not ready for what we call e-justice, and therefore suffered a lot from the measures taken by the court system and the judicial systems. So reorganization of work is the main one. You can see on duty systems, but you can see a high number of temporary suspensions of court hearings, 69%. Temporary suspension of face-to-face attendance in court buildings, 71%. Temporary suspension of processing of judicial cases, it's only 12%, but still that creates an even worse backlog of delayed cases. Temporary suspension of evidentiary protections, that's still at 27%, which is very high. And temporary suspension of the need for parties to comply with case management rule and orders, it's 43%. Of course, many judicial systems did not have fully digitalized case management system, which explains partly the results here. So, use of technology by courts to avoid face-to-face contact, and here, of course, we do have lower numbers as expected. So, videoing has been a good practice in quite a few countries, but not in all. Digital systems to enable lawyers to file a lawsuit online. Well, it's sometimes very reduced. It's just an exchange of emails rather than anything else. Online processing of judicial cases is, of course, a bigger issue. Call centers to enable communication between parties and or lawyers and court staff, that's quite rare. Cell phone to enable communication between parties and or lawyers and court staff, that's better. And so on and so forth. So here we go. I mean, this is the picture. We just repeat the survey a few months later. Legal aid has been affected dramatically by COVID, as you can see from this slide. So, and so on and so forth. Those are just examples, or they are just data or findings to try to enhance or to try to emphasize the role of law, especially in times of crisis. The EU Justice Scoreboard of June 2020, which takes into account, which reports on data prior to COVID, okay, has quite a blurred picture of the efficiency, and the quality and independence of justice in some of the EU member states. You can have a look at it. It's an interesting report if you haven't seen it yet, with very interesting graphs. Some member states recurrently do not provide information. Cyprus is one of them, but not the only one. So this is, I mean, we are very looking forward to the next scoreboard that will be post-COVID-19. And that shows in itself that the authorities in the various member states may not be ready, fully ready, to even give data. So it's probably a problem of organization, lack of resources, lack of organization. And this is something that we picked up, all of us in our respective fields have picked up. We at UCLan Cyprus established what we call the rule of law monitoring mechanism. It's basically a website. You can go and visit it, and you're welcome to even participate to it if you have something to say. And we have tried to publish relevant blogs on various aspects of the rule of law in times of COVID-19. So Despina and Dimitra, whom you know already, who participate to the project, they wrote a very nice piece on justice in Cyprus in times of COVID-19. And I'm sure that they could write something for the EU-En4s blog as well. From what I could see on the blog of the project, I think it would fit quite well. I wrote a piece or several pieces on, the role of the rule of law and the impact, the negative impact of COVID-19 on the rule of law, not only in Cyprus, but if you compare with other countries, and in particular, if you compare with the UK, the comparison is quite striking. So we are concerned with the questions which appear in the scope here. These are broad questions, and they are questions around the sustainability of the rule of law, the continuous protection of the rule of law, and anyone is welcome to join us in that monitoring. So on this basis, on the basis of the rule of law and on the basis of a wide or broad interpretation of what the rule of law means, the way Lord Bingham, for example, has referred to it, I think we all agree that strict adherence or strict compliance with the rule of law is necessary, especially in times of crisis and irrespective of the constitutional traditions and values of the member states. So that strict compliance is actually applicable as soon as possible. It's not only for the judicial system, obviously, to work on, or the justice system, but it's a principle that must be complied with when drafting and implementing measures at the national level, and this applies to all branches of government. So the rule of law is a way to constrain the exercise of public power and protect against its arbitrary use. The idea is in particular to reduce the amount of cases that would eventually end up at court and thereby improve the quality of justice. So through my research all those months, I kept thinking about what principles I thought were very important to catch not only the work of the judiciary, but to catch the work of all the branches of government. And of course, there are the usual principles of good governance, one shall say, such as transparency or fairness or due process. These are, of course, extremely important, and they are embedded in good governance principles. But I was thinking of looking more at the EU level, and I was wondering whether there were principles which we use in EU law in everything we do, especially when we talk about the enforcement of judgments, that could be useful in the context of the current public health crisis. And I kept coming back to those three principles that are highlighted here. The first one being the principle of precaution, or precautionary principle. The second one being, of course, proportionality, and the third one being effectiveness. And of course, those three principles, they do not apply irrespective of each other, and they do not apply in a vacuum. So there needs to be a coordinated or collective approach to those principles. And if you look at the example of the UK, if you look at the lack of coordination in the UK with the rest of the European Union, of course, due to Brexit in particular, you see an example of how the lack of coordination at the supranational level can lead to much worse results by not following simple guidance from the World Health Organization or the EU equivalent, the EU equivalent body. So in terms of the precautionary principle, I'm sure you're aware of it, you know it in a different context, probably in the context of the free movement, and here we are talking about the free movement of judgments. And the precautionary principle is interesting because it allows the mitigation of risks, and in particular the mitigation of risks to public health, which is exactly what we're talking about here, human life and public health. So it is a principle that has been exercised by various member states of the European Union in a very different manner, with very little coordination or not enough coordination. And one may wonder why there is so little coordination. Of course, we have seen coordination in some aspects of the precautionary principle, in particular in terms of medical equipment and essential medical staff. There one can say that there has been a true EU effort or EU coordinated effort to allow the medical staff and products to flow throughout the European Union. But much more was needed, probably, to do that. The principle of proportionality, of course, we are all very familiar with it. And the principle of proportionality has been applied and is supposedly applied very early on, including by the executive, by looking at the necessity of a measure vis-à-vis the general public interest. Hopefully rationality is being used when determining the proportionality of measures, although we can sense that we have seen examples of lack of rationality. The principle of proportionality is, of course, very important as well when we are now looking at the orderly exit from measures. And when we say orderly, we mean coordinated and well thought through, well rationalized, and well explained to people. And again, we don't see this. We see measures going and coming and going with very little explanation of the reason why these are necessary. An example is, again, in the UK, because the judicial system in the UK is so well organized that cases tend to be heard more quickly than quicker than in other jurisdictions. So a few cases for interim reliefs in particular have already reached the UK courts, and I suspect that this is the case in other jurisdictions where you are familiar with. I haven't looked at it, but in France, for example, there have been also quite a few cases that have been that have reached the courts, but they are more likely dealing with the constitutionality or the lawfulness of the measures at the constitutional level, not necessarily on the application of proportionality. So this is an interesting case. It has to do with the school system in the UK, not the court system, but the school system. But the evaluation of the necessity and proportionality vis-à-vis every human right that is relevant to the right to education under the Human Rights Act of 1998 is quite interesting. So I encourage you to have a look at the balancing exercise that Justice Lewis provided. And it's interesting to see, or sad to see, that the balancing exercise was done exclusively on the basis of the domestic legal or the ECHR, but the ECHR, of course, is embedded into the Human Rights Act 1998. In terms of the principle of effectiveness, and this is probably where the European Union and EU law has had a major impact, raising effectiveness through a fundamental core of EU law. And not only, taking into account not only EU instruments, but also the Convention, the European Convention on Human Rights. So effectiveness is key, and effectiveness is key in particular to look at oversight mechanisms that are now being put in place. So the measures, the emergency measures were first put in place, and now the oversight mechanisms are being put in place, and effectiveness is a key here. Now, these three principles, in my view, are fundamental to the enhancement of access to justice in times of COVID-19 public disaster and beyond. And they need to be applied early on, including by the executive, so as to mitigate recourse to legal redress. We don't want to see a worse situation in terms of access to justice due to COVID-19. And unfortunately, we have seen figures and data. It looks like COVID-19 has worsened the situation in terms of access to justice. So I would encourage you to have a look at some calls for evidence of the UK Parliament. I don't know if other parliaments in the European Union have something equivalent. I looked at the French equivalent and couldn't find something really as well as organized and as clear as the UK Parliament. So I would encourage you to look at the many calls for evidence on the impact of COVID-19 measures, and there are multiple fields. We submitted one call for evidence. You can visit it here if you can see, and you can read it. It's publicly available, which is the other good thing about public consultation exercises in the UK. And of course, you don't need to be UK based or UK citizen to participate. So in terms of resources, if I were to suggest to you a few resources along those lines, well, if you would like to read that, the way we interpreted those three principles between Cyprus and Great Britain, because they are both islands, so we compared the two islands in particular because they have such strong historical and legal links. So you can find that blog piece, which is quite long and quite intense, which I think you will find of interest. At the international level, there is a very good series of blogs by the Verfassungsblog. I'm sure that you know it. It's an online symposium on the state of emergency in, I think it's close to 80 countries in the world. Probably your country is there too, and that it has an EU dimension, it has an international dimension. It's really good stuff. In terms of Cyprus, you can have a look at the blog that I mentioned before, the one written by Despina and Dimitra, and the one I wrote with Andrea on the legal framework. I guess you're aware of the FRA bulletins on COVID-19 that are quite interesting, and every bulletin focuses on a specific issue. That access to justice is still there everywhere. So there was a bulletin on the vulnerable groups. There was one on the use of artificial intelligence and technology in times of COVID-19. And of course, access to justice is paramount to those issues. And if you are not familiar with the Reconnect project, which is a Horizon 2020 project on the rule of law, well, maybe it's time to have a look at what they do. And they published a very interesting set of recommendations on how to uphold the rule of law and governance in public health emergencies. So it's an easy tool to use, including in what we are doing in this project, in the EU-En4s project. So I think I would like to see perhaps a bit more on COVID-19 into what we do. What could be the potential problems brought by COVID-19 into the enforcement of foreign judgments? There's bound to be some specificities. So this is all I wanted to say in terms of introduction. I will unshare my screen.